My name is Meg Kurlinski. I work at Godfrey & Kahn in Milwaukee, Wisconsin, and I practice with the employment and labor team doing mostly management side advising. I wrote a little article on Wisconsin and Federal Family Medical Leave Act and some tips in recognizing the differences between the two laws. When addressing a Family Medical Leave Act issue, practitioners need to not only be aware of the Federal Family Medical Leave Act, which generally provides 12 weeks of unpaid job-protected leave, but they also need to be aware of the Wisconsin Family Medical Leave Act, which provides similar, but in some respects more generous benefits that employers and employees need to be aware of. The differences between the two laws really start as early on as determining employee eligibility under the laws. For purposes of federal law, employees need to have worked for the employer for 12 months and in the 12 months preceding the request for leave have worked 1,250 hours. On the other hand, in Wisconsin, employees need to have been employed by the employer for at least 52 consecutive weeks, and in that 12-month period preceding the leave request, need to have been paid for 1,000 hours. So the two differences there are clearly the amount of hours that need to be had to trigger the law, but also how those hours are calculated. For purposes of federal law, the hours are calculated by actual hours worked at the desk or on the floor, and for Wisconsin law, it's the hours that are paid. So any paid leave, such as vacation or other kinds of leave, would go towards that trigger. When you get into administering leave and the kinds of leave that are covered under the laws, there's also some differences as well. For instance, in Wisconsin, you get leave to take care of an in-law, and under federal law, you do not. The federal law has been amended several times recently to extend a service member leave benefit that isn't available in Wisconsin. Under federal law, there's two types of service member leave. We have qualifying exigency leave that arises when a service member is called away to active duty, and family members need to pick up banking responsibilities, caregiving responsibilities, and some of those associated needs that are created when someone's called to duty. It's qualifying exigency leave. And then the other form of service member leave is just service member leave to care for an ill or injured service member. Leave available again under federal, but not under Wisconsin. Probably the most common form of leave is leave for a serious health condition, either the employee's own serious health condition or the serious health condition of a family member. Both federal and Wisconsin leave provide for that form of leave, but the definition of serious health condition is different under both laws. Under federal law, a serious health condition is anything that requires inpatient care, so that can be an overnight stay in the hospital. It's also incapacity lasting 3 or more consecutive calendar days that require 2 or more follow-up treatments by a healthcare provider. Wisconsin has a much more simplistic definition. It's an incapacity that requires inpatient care, again, hospital care, or it's any incapacity that requires follow-up treatment by a healthcare provider. What is glaringly different between the two is that there's no requirement that there be 3 consecutive days of incapacity, and it's a frequent area that people overlook, and it means that employees generally trigger the FMLA protections in Wisconsin a little quicker than they do under federal law. One other important factor to keep in mind when administering family and medical leave in Wisconsin is the difference in the basic leave entitlements under federal and Wisconsin law. Under federal law, there's 12 weeks of unpaid leave in a calendar year that can be taken for any combination or multitude of eligible leaves under federal law. Wisconsin, on the other hand, apportions out the different leave entitlements that employees have. In Wisconsin, employees have 2 weeks in a calendar year to care for their own serious health condition, 2 weeks in a calendar year to care for the serious health condition of a family member, and then 6 weeks of bonding leave, which is the leave associated with the birth of a child or the placement of a child from adoption. It's important to keep those in mind because they might run concurrently. If you have an employee that goes out on a long portion of leave, say for a hip replacement, and they're gone for 12 weeks, they will have exhausted the 12 weeks under federal law and the 2 weeks for their own serious health condition under Wisconsin. But if they would then need to take leave for the care of a serious or the care of a family member sometime down the road, although there's no federal leave available, there still is going to be 2 weeks of Wisconsin leave available. generally, those are some of the high points of the differences between federal and Wisconsin family and medical leave. There's a couple additional differences and tips in administering Wisconsin and federal family and medical leave in the article that you can find online.